So welcome to the session on the impact of online content moderation and curation on fundamental rights, how to assess, mitigate, and monitor systemic risks on online platforms. I'm David. I work for the EU Fundamental Rights Agency. The agency is tasked to provide data and analysis, amongst others, on fundamental rights issues to the EU institutions and member states. And of course, in the past years at the agency, we realized more and more the importance of online content moderation, and its impact on fundamental rights. On that note, we published a report last November on current challenges of online content moderation. There are very few copies left of this report. We have a booth for the Fundamental Rights Agency just behind you, outside the Grand Hall, and then you can also grab a few publications and also talk to colleagues. So in our report on online content moderation, that was the first report where the Fundamental Rights Agency addressed this topic, and we collected data from selected social media platforms. We found high levels of hate targeted at women, also varying levels of hate targeted ethnic minorities, high levels of harassment. But apart from painting a picture on online hate on online platforms, we also discussed the challenges of moderating online content. This, of course, has changed a lot in the past years because the landscape of online platforms has changed and is changing rapidly at high pace. We also work on artificial intelligence at the agency. We published a report on bias in algorithms. As you know, content moderation is heavily supported with the use of new technologies and artificial intelligence, which also creates another challenge. And lastly, we won't stop there, so the agency is looking into the future and see how we can do more on addressing the questions of fundamental rights protection on online platforms. And this is why I'm so happy that I can moderate this panel and gathered a great round of experts to highlight current issues on online content moderation from a fundamental rights perspective. We focus on a very important new law, the Digital Services Act, which includes several safeguards to fundamental rights. And as the DSA is quite a big law, we focus on specific aspects, most notably Article 34 and 35 of the Digital Services Act, which requires very large online platforms and very large online search engines, which are those that have users which are at least 10% of the EU population or more, to do risk assessments to systemic risks on an annual basis that stem from the design and functioning of their systems, and then also come up with reasonable and proportionate mitigation measures. Among those systemic risks are also fundamental rights, and those include the right to data protection and privacy, rights to the child, non-discrimination, freedom of expression, and several more. One other challenge that is also picked up in the DSA and we'll discuss in this panel is how do we actually learn about those risks? And obviously there is a known challenge of accessing data at online platforms. And here the Digital Services Act also has Article 40, which should allow for better access to those platforms. When we at the agency did our research, we also had problems accessing data of platforms. So I think there's a general agreement that the Digital Services Act reads well and has a lot of promising provisions on fundamental rights, but that the implementation is very challenging. It only entered fully into force in February this year, and we're in the middle of its implementation. So after that quick intro, I'm really happy that we have not just good experts on the panel, but also gather different perspectives on this very topic. So we have Eike Greve from the European Commission here. We have Valentina Golunova from Maastricht University, representing academia with a legal perspective. We have Daria Dergacheva from University of Bremen with a computer science perspective. And last but surely not least, we have Eliška Pirkova, representing human rights law expert from Access Now as a civil society representative. So we'll open the panel with a first round of 7 minutes to each of the speakers. I introduce them a bit more before they speak. Then we have a second quick round, and then I'll make sure that we have at least 25 minutes for questions and answers from all of you. So first one, Eike Greve, you're a policy officer at the Digital Services Unit of the European Commission, DG Connect, focusing on the effective enforcement of fundamental rights in digital contexts, working on the implementation of the DSA. Previously also worked in DG Justice, in the Fundamental Rights Policy Unit, working on the AI Act, for example, and also on the Code of Conduct to counter hate speech online. Eike, the floor is yours.
Thanks a lot, David, for organizing this panel, which is very important and very interesting, and then also for inviting us. Yes, I would maybe put a bit the risk assessment and mitigation mechanisms of the DSA into context, and then also go into some of the details, which could be then a good basis for the following discussions that we will have. Of course, the main objective of the DSA to ensure a safer online environment for the users, to have the same rules everywhere in the EU for the service providers, and at the same time, wherever we have interventions that concern how content is moderated or recommended, that we do that in a way that is, of course, fully aligned with fundamental rights, and notably the freedom of expression. So we have the objectives of the law to improve everyone's online experience, and we do it in a very careful way to avoid creating new risks, and also by addressing some of the risks. And there are articles in the DSA that go to this purpose without being called like that, and that apply to all the providers of all the online platforms. Let's take the notice and action mechanisms that they have, where people can flag content that they believe to be illegal. Let's take transparency provisions, for example, on targeting of advertisements, or the transparency of content recommendations. So all of these things already mitigate risks that can stem from online platforms. And then we have this specific regime, as David said. It's only for the providers of the biggest platforms with more than 45 million average monthly users in the EU. And this regime is, if you want, consisting of two main pillars, and then it interacts also with other provisions in the DSA. And I think we have a lot of focus often on the main articles, 34, 35, but I wanted to also point to some of the others. So, of course, 34 is the obligation to assess the risk stemming from the service. And this is then spelled out in more detail. It would be stemming from any of the systems that are related to the service, and it would be from their design, from their functioning, and also from their use. So that's important, for example, when you think of risks to civic discourse and elections in terms of foreign information manipulation operations, right? So also the use and abuse is explicitly covered by these risk assessments. I will go more into detail on the requirements that have to be assessed, but I'm still in the overview. So the next step is then Article 35, which requires that the providers mitigate the risks that they identified, assessed in a way that is proportionate, effective, and reasonable. So that is the legal requirement, to have this mitigation. And then there is a non-exhaustive list of measures that they can take to achieve this. So that's how Article 35 works. And there are many of the risks that are very well known and studied for many years. So let's say disinformation is an area where there was a lot of research for many years, how it works and also how it can be countered. Many of the phenomena are not new. But we also have risks that keep constantly changing, where we need to understand them, where we need to see how they develop. And there are also areas where there is, let's say, less academic research. For instance, risks to public security stemming from the use made of those very large online platforms. And here I want to point to this Article 40 that David also already mentioned, because the same providers that have the risk assessment and mitigation obligations also must, in certain circumstances, give access to the data that they hold to researchers that want to study the risks and their mitigation. So this is this famous Article 40. We will soon come out with a delegated act on its implementation. So still this year, the Commission will come with this delegated act. And the idea is really to enable access to the data and to better understand the risks. And then the research output, of course, will inform how the risks can be assessed, also identified in the first place, identified, analyzed and assessed, and then mitigated. And this is really thought of as a cycle. You can see it also if you look at the recital 90 of the DSA, which says that these risk assessments should be done on the best basis of information, and it mentions explicitly scientific insights, right? So it also mentions that the providers should consult with people affected by their services, with representatives of users, and with civil society organizations, which is very important for the Commission to also underline at every occasion we get. So this is part of the system. Another article I wanted to mention is Article 39, which also helps to mitigate the risks and to identify them. It is the requirement on those big providers to keep an ad repository of all the advertisements that they are presenting to users, the whole duration that they show them, and then also 1 year from that moment, 1 year on. And this has already led to research output published by civil society that found indications of risk based on those ad repositories, and that helped then, of course, to learn about the risks. And the Commission is taking such publications into account, as we do with any relevant information. So I spoke about the flanking articles around 34, 35, and I want to still plug one other panel that will happen on Friday morning. It's our colleagues from the ECAT, the European Center for Algorithmic Transparency, that will organize it. And there it will be all about the Delegated Act on Data Access and on how also the researchers can meet the requirements to get that access. It will be at the same time, 11:50 on Friday. So of course that's a big recommendation. David, how much time do I have left?
None.
None? Okay, no, that's fine. Then we continue discussing later, okay.
Thank you. No, it was exactly the 7 minutes. Thank you for keeping the time. Yes, because we want to hear out first all different perspectives. And the next one is, from a legal perspective. It's my pleasure to introduce Valentina Golunova. She's an assistant professor in digital democracy at Maastricht University, a part of the multidisciplinary research project on disinformation and its impact on democratic processes, funded by the Dutch Ministry of Education. Valentina recently defended her PhD on algorithmic content moderation and freedom of expression. Ongoing research project concerns transatlantic dialogue on platform regulation, the EU's legal approach to disinformation, strategic litigation in the field of digital rights. Valentina, the floor is yours.
Thank you so much, David, for having me on this panel. And I would just like to talk about how Articles 34 and 35 of the DSA challenge our conventional thinking about fundamental rights. Yes. So when it comes to the management of risks under the DSA, we depart significantly from our conventional approaches that we have under fundamental rights law, because we're not interested in whether there has been an unlawful interference with fundamental rights by platforms, but rather we treat the compliance with fundamental rights as a scale, and we assess the impact that these platforms have on these rights. And in my recently defended PhD project, which David has just mentioned, I try to adopt this novel way of thinking and imagine a framework for assessing and mitigating risks to freedom of expression posed by algorithmic content moderation. And I have identified 5 ways in which algorithms challenge the enjoyment of freedom of expression, and not just because algorithms are necessarily error-prone or less knowledgeable than human moderators, but simply because the entire governance model produces certain unique effects that impact on the user's ability and willingness just to speak out online. But of course, freedom of expression is only just one fundamental rights mentioned under Article 34, 1b of the DSA. And what makes the risk management framework so challenging is that we cannot simply create these kind of frameworks for each fundamental rights without assessing the broader context. And we always have to see how exactly our mitigation measures would then correlate with the mechanisms that we'll have under previously adopted legislation. We need to think about different intersections between fundamental rights. And of course, we ultimately also have to be honest about the potential and the limitations of the fundamental rights framework. So I will just illustrate some of these challenges that I've mentioned. So considering the topic of the conference, I will start with the rights to privacy and data protection. And here I see a complex question regarding the relationship between the risk management framework under the DSA and the DPIAs under Article 35 of the GDPR. And of course, these mechanisms have different objectives, also different scope, but in some instances, there's also a significant overlap between them. And we know, for example, from the EDPS opinion of 2021 on the DSA proposal that when platforms use automated content moderation systems, then in most situations, the DPIA would be a mandatory tool to use. But then it's not clear whether then the DSA requires the VLOPs to do anything extra than is already prescribed under the GDPR. And this uncertainty might also create the two overlapping workflows and impair the effectiveness of both tools. But turning to the second issue, we should also be aware that the assessment and mitigation of systemic risks to some fundamental rights can impact on the mitigation of risks to other rights. And once again, if we take the rights to privacy and data protection as an example, we can see how it can come into conflict with freedom of expression. So for example, once again, in my PhD dissertation, I discussed the possibility for using an intersectional framework for assessing the risks to freedom of expression posed by algorithms. But of course, in order to really use this framework, platforms would probably need to process special categories of personal data under Article 9 of the GDPR. But we know that as a general rule, such processing is prohibited. And just at first sight, I wouldn't think that any of the exemptions that we also find in the GDPR would apply immediately. So the existence of a systemic risk to privacy can also limit the mitigation measures when it comes to freedom of expression. And I think that the rights of the child is also a good example here, because there is a growing demand for enhanced child safety on the internet. And just last week, the Commission launched a formal investigation into the protection of minors on Meta, as you all know. But there is a big debate between the interplay between child safety and other fundamental rights. Of course, we can think about freedom of expression, and this conflict has recently become prominent in the US, when some states, for example, have adopted legislation requiring platforms to ensure age verification for adult content. But that raises also issues regarding freedom to receive information. And then when we have age verification, obviously that also entails the collection and processing of additional data of users. So once again, we can think about the need to have additional measures for the mitigation of risks to the data protection here. And finally, I would just like to underscore that simply requiring VLOPs and VLOSEs to assess and mitigate systemic risk to fundamental rights is not a silver bullet, and it's not always sufficient to ensure a fair and equitable outcome for users. Because many fundamental rights in the EU come also together with their kind of problematic heritage and with their own limitations that we have to be mindful of. And for example, we can take the right to non-discrimination that is also explicitly mentioned in the DSA. And it has been critiqued a lot by the scholars and by civil society because the list of protected grounds under Article 21 of the EU Charter of Fundamental Rights is limited. And that leads us to the situation when certain forms of discriminatory treatment by platforms would probably fall outside the scope of this article, and we can ask ourselves whether platforms would then need to also mitigate such risks. So we can think of discrimination based on socioeconomic status of individuals, which happens a lot in targeted advertising, or discrimination based on gender identity, also considering the limitations on the visibility of the LGBTQI+ content on the internet. So yeah, the fundamental rights framework is ultimately not the perfect answer, and we might also need to expand our horizons and think about potentially other solutions as well. I will leave it at that. Thank you so much, and I look forward to the discussion about all of these issues.
Sure. Thank you, Valentina, for this good overview and reminding us about also all the challenges that we have on discussions on fundamental rights that also appear now on the surface when we discuss the use of new technologies. But of course also mentioning issues that are new, and I think scale is a big question. Of course you can discuss from a legal perspective one post with its context at length, but the sheer scale of post and online content is really a game changer in a way. And that's the transition to also having a computer science, but also interdisciplinary perspective brought to this panel. It's my pleasure to introduce Dr. Daria Dergacheva, who is a postdoctoral researcher at the Platform Governance Media Technology Lab at the Center for Media, Communication and Information Research at the University of Bremen. Her work includes contributing to the project Recreating Europe, rethinking digital copyright law for a culturally diverse, accessible, creative Europe. Her dissertation was on the state narrative construction on Twitter, a case study around new stories on LGBT issues in Russia. The floor is yours.
Okay. Do I use this? No. Okay. Hi, everyone. Have you ever felt like an imposter? You don't have to answer. The thing is, I'm here by pure coincidence. My colleague, who is studying hate speech and knows a lot about fundamental rights, was supposed to come. Me? I was born in the Soviet Union, so not so much, especially about things concerning privacy and data protection. But I had to go, gather my courage, and come to represent the lab. Let me introduce you. Platform Governance, Media and Technology Lab at the University of Bremen. We research various aspects of governance by platforms and AI, including content moderation, as well as a lot of other fun things. Now, the photo which is circled in red is Dr. Viejo Otero, whose fault it is that I'm here representing all of them. Our lab also collects a curated archive of platforms' policies since the beginning of their existence. Please reach out if you're interested in researching those with us. I'm going to talk about governing of misinformation, which seems like a very hot topic, not just recently, but quite for some time. But this year especially, and in the framework of DSA, there had been multiple reasons to analyze how platforms govern the speech connected to misinformation. As you all probably remember, somehow misinformation was declared as the biggest threat at the World Economic Forum, bigger than climate change. I mean, what? However, in spite of numerous EU Commission requests looking into ways platforms deal with it, misinformation as such is not illegal speech. In our lab, we are now doing a research of all the terms and conditions and community guidelines of the 5 major platforms: Facebook, Instagram, TikTok, YouTube, and Twitter, which is now X. Through semantic network analysis and further qualitative readings, we study how the concept representing misinformation changed through time. It is early to talk about concrete results, but I will show you some sketches of the quantitative part. Here is the graph, which represents the growth of mentions of words semantically connected with misinformation in Facebook's policies from 2008 till the end of 2023. And here you can see a comparison of semantic networks around misinformation, concept by YouTube in 2006 and in the end of 2023. As you can clearly see, the concept becomes much more elaborated on. Many more topics appear in these private regulations of speech. Oops. Of course, now we have the Digital Services Act, which implies that platforms explain their content moderation decisions. Here is a graph from the DSA Transparency Database page, which shows how many detections of what to moderate was automatic and how many decisions had been automatic afterwards. To be honest with you, this graph makes me a bit confused, so I will focus only on the detection part now. It doesn't help that I sat on my glasses while on the plane here. But let's see. Over 70% of the detection was automated. And then there's the partially automated category, which according to descriptions in some platforms' transparency reports, is involving a human decision somewhere in the process, but we are not sure where exactly. The DSA Transparency Database includes misinformation into the category which is called negative effects on civic discourse and elections. As it is visible in this graph, during the time this database exists, starting from September last year, most of moderated content in this category belongs to TikTok. The second one is Pinterest. And I am seriously thinking on prohibiting my teenage daughter to browse this malicious network. X, meanwhile, reported only 3 instances, Facebook 3,000, Instagram 12, and LinkedIn over 2,000 decisions. This is also a surprise for me. However, in their misinformation policies, platforms also refer to COVID-19 crisis, and those would probably fall into another category. Risk for public safety. Here, Facebook and Instagram, along with somehow AliExpress, are picking up the path. A question for the audience now. Please raise your hand who thinks it helps to understand what kind of speech had been moderated by AliExpress or Facebook or Pinterest. Really? Oh, that's great. Well, not really. There are literally billions of statements of reasons submitted, but there is no way to actually know what kind of content was in this moderated content. So, sad as it might be, researchers still have to invent other ways to know which content had been taken down. It is notoriously difficult to study. Qualitative methods show users' frustration, gossips and myths surrounding content moderation decisions, especially felt at the disadvantaged communities. Computational methods have to rely on seeing the content disappear, although even these rather desperate research designs are usually prohibited by platforms. So, in the spirit of DSA's Article 40, Meta is closing down a researcher tool, CrowdTangle, and rolling out another researcher access program through API content library. It does have more data, which is a good thing for the academia and civil society. Journalists are not getting access. But please raise your hands who works in academia or civil society. All right, great. Now please raise your hands who knows Python. Not too bad, but now you also need to know Python to be able to use this, which puts an additional barrier to become one of the already vetted researchers. Also, it still doesn't give an opportunity to study which content exactly is moderated. Moreover, as Martin Husowitz of the London School of Economics highlighted, platforms only have to moderate what is illegal. But disinformation, or even more so, misinformation, is usually not illegal. So how do we know what do they moderate and what they don't? We're as much in the darkness as before, and other methods of research are needed. I could talk more, but...
Perfect on time.
Okay. Thank you so much, and...
Thank you very much. No, and thank you for keeping the time. Of course, we're taking a bit longer as usual, but still manageable. No, thank you for highlighting this perspective from computer science and also critical perspective. On the other hand, also like being data scientist myself, I find it exciting to see these new databases coming up and then researchers jumping on it and starting to analyze them, producing graphs, which is, I think, a good start into getting insights into what's happening online. So to finish the round, last but surely not least, as I said, I introduce Eliška Pirkova, whom I don't have to introduce to most of you working in this area. She's a senior policy analyst and the global freedom of expression lead at Access Now, a leading international human rights organization that defends and extends the digital rights of online users at risk around the world. Eliška works much on freedom of expression, content governance, platform accountability, human rights law by training, and also advises international organizations like, for example, the Council of Europe Committee of Experts on Combating Hate Speech. Eliška, the floor is yours.
Thank you very much. It's a great pleasure to be here today. And we heard a number of great presentations and observations about how we are doing with the DSA so far. And so I would like to step in as a civil society actor or external stakeholder with hopefully relevant expertise, which is not only represented by me, but also by my colleagues. And what it was already mentioned, we are also a global organization. We've been extensively working on the issues of content governance and content moderation, as much as content curation, and as well how the content policies are being designed and enforced by platforms, which is also singled out by Article 34 as one of those systems that can impose either a systemic risk or a negative effect on fundamental rights. And maybe just to quickly complement what was said before, of course, the risk to, or effective or the negative effect on fundamental rights is not the only aspect that Article 34 covers. It also covers other societal risks that are at least mentioned in the DSA, and the list remains intentionally open-ended. But also ourselves, being a human rights organization, we looked a lot into how these fundamental rights impact assessments should be conducted and what the Commission absolutely have to assess once risk assessments are being delivered by very large online platforms. And I get to that in a minute. But maybe going back just to give a quick overview what everything happened since DSA came into its force. First, when the law became applicable to very large online platforms, and they had to submit the first risk assessments. And many of you are also aware of Recital 19, the DSA, which actually directly calls on platforms to involve civil society organizations in the process of conducting those risk assessments. And of course, there is a lot of dispute about what is the legal power of the recital. We heard from the court in the past that it doesn't necessarily have legally binding power. But at the same time, this sort of a nudge was clear indication that also triggered high expectations from us to perhaps being approached by platforms when the first round of risk assessments was run. And without keeping you in the dark for too long, we were not approached by very large online platforms during this first round. But we were not also waiting. We actually approached platforms ourselves, and we started asking questions where you are in the process, how do you actually factor in the Charter of the Fundamental Rights, and we try to sort of analyze the landscape, how they are getting ready. This was an incredibly difficult process because platforms often treat these risk assessments as a confidential exercise. And we also kept asking about those existing risks that were largely already documented, from negative impact on content policies, especially in times of crisis, for instance, the negative impact and discriminatory bias on underrepresented groups that is also addressed in the recent report by the Fundamental Rights Agency. And how actually this will be properly factored in. To this day, we don't have access to risk assessments yet, neither to their redacted version, so it's very difficult to assess the quality of this exercise for external stakeholders. And let's see what the future will bring. But overall, we are still at the early days and at the beginning of this process. Content moderation and content policy specifically were already widely researched. A number of these systemic risks have been proved that they probably do exist. Of course, it's not only about developing these content policies, but also how they are being modified and enforced, especially if they are responding to other externalities and changes in the political landscape. And similarly, the issue of opaque algorithms and algorithmic content moderation has been also widely analyzed. So from our perspective, we very much looked into the angle of fundamental rights impact assessments, and we provided sort of criteria and recommendations that can be then found in the specific report and in further work done by Access Now and other civil society organizations on what essential components this fundamental rights impact assessment must contain. And the reason why we chose to go this direction was because there was no proper guidance provided to very large online platforms at the beginning during the first round of those risk assessments. And so even though Article 34 does contain direct reference to informal guidance that the Commission may eventually issue in the future, we felt that this is a very specific momentum when we can actually influence those processes and we can somehow shape their meaningfulness to avoid that they will become just checklist exercise. And so we put forward a number of recommendations and criteria, basically how to assess the risk assessments for the Commission to understand what, in our view, are those most essential criteria and components that have to be factored in. And just to mention a few, we definitely demanded a detailed description of the service structure, where we also partially became inspired by what's written in now concluded EU AI Act. We then demanded a detailed description of the fundamental rights impact assessments methodologies, which in our view is absolutely essential. And even if we were not able to receive the full access to these risk assessments in the future as external stakeholders, we would like to at least see the redacted version of those. And this redacted version should contain certain minimum standards, and the platform can never go below that. Another of those would be, of course, the preliminary assessment of all negative effects on fundamental rights and freedoms as defined in the EU Charter. Those of you who saw Article 34, you know that there are a couple of fundamental rights being listed, but of course, VLOPs have to conduct the assessments against the Charter as a whole. This is not a cherry-picking exercise. And we also heard from platforms when we inquired about how they are doing and how they are coping with this new obligation, that how challenging the Charter of the EU was for them as a sort of a new international Bill of Rights. And in our report, we also dedicated a very specific section explaining why it isn't actually that much difference and where those differences lie. And finally, also an in-depth assessment of significant negative effects on fundamental rights, future mitigation risk measures or actions following these fundamental rights impact assessments that should be really properly described, and explain how they actually address these fundamental rights impacts. So this is just a quick overview. We looked into other elements of fundamental rights impact assessments that are relevant, including, for instance, meaningful stakeholder engagement. And this is the final point that I would like to raise, because I'm pretty sure I'm reaching my 7 minutes. So as I said, there is no direct legal obligation for platforms to consult civil societies. But at the same time, we did experience long years of different sort of efforts to consult civil societies by private actors that are not exactly delivering to its outcome, that do not give us a proper platform how to deliver the feedback or monitor how this feedback is actually being taken on board. We do believe, however, that now with the DSA and with the European Commission being in charge of the enforcement of this specific regime over VLOPs, the formalized model of the engagement in civil society is a must. For us, having equal footings behind that sort of enforcement table where we can meaningfully contribute to the level of enforcement and to the quality of how platforms actually comply with this criteria is the key. We do know that there are, of course, a number of core regulatory measures under the DSA where we may or may not have a possibility to influence those and shape them. But this formalized mechanism, either in the form of expert committee at the Commission level, is a #1 priority for the civil society organizations to achieve. And this would also include one final point, the non-EU voices. Even though DSA applies only to the EU jurisdiction, we do know that a non-EU organization gathered a huge expertise, and they do understand those systemic risks DSA seeks to tackle, because as we all know, stating the obvious, Internet doesn't have borders after all. Thank you very much.
Thank you, Eliška. To all the speakers for the round. We're running a little late. It's my role to keep the time, so I'm just, without further ado, open for a quick second round, so you have the chance to react to what others have said. Also, if not focusing maybe on next steps, I'm fully aware we can't cover everything. It's such a big topic, and that's also why it's a sort of a kickoff of this topic at the conference, because others will tackle these points as well. But without further ado, please, Eike, if you have 3-4 minutes for reactions, please.
I try to. Maybe show me if I'm getting close. Yeah, I have some reactions. I do in the same order as you spoke. I agree, Valentina, that it's important to have transparency on content moderation, both by means of automated tools and also when people do it. And so for those who are interested, also to be short with the time, we require layered intensities of transparency reports. All the platforms have to report on their content moderation, and then the very large online platforms, again, they have to do more. And for them, the reports which they have to publish every 6 months, they also have to include, for example, how the human content moderators are trained, what their resources are, and for the automated tools, they have to indicate the accuracy, not only in general, that's actually for all the platforms, but by member state language in which they offer their service. So we do require quite a bit of concrete transparency in the content moderation tools. It doesn't mean they cannot fail or create problems, but that way we know, right? So there is quite a focus on that. Then I also agree with you that the DSA does not solve all problems that we have in our societies. And I'm actually happy about that, because a concrete problem definition makes for a good law, right? But I can't help but going to this point on the limited protected grounds in EU non-discrimination law, because the Commission did attempt to harmonize this, because some member states, such as Germany, have a higher level of protection and more protected grounds, but others don't. So there was a proposal, but it's stuck in council for many years now. But it's clear, it's on the radar of the Commission, and we try to also go to these adjacent fields, which then, of course, if it's improved there, without any need for change, will also be more effective thanks to the DSA, because it's built on top of that. To Daria, I'm so happy that you said something about the transparency database, because it was the colleagues who built a dashboard and to give the output. So even if you say you don't know what a partially automated decision is, it's great to see people react to it. And that goes to everyone in the room. Please make use of the database. We also try to have the dashboard and to make it more usable. And any constructive feedback of what you need is really appreciated. Of course, within the limits of our mandate and the article itself, but yeah, that's great, and we see that there can be a benefit in further harmonizing the reporting, and so there will be an implementing act on the transparency reporting also still this year, including templates on how they should report, which we hope will improve then the usability. Then I have seen I have only 1 minute left. We also have a terms of service database, actually, that we host, so you can also use that and monitor the changes in terms of service, including for content moderation policies. And on the point Eliška raised on the access, the non-access to risk assessment reports, that we do encourage, including in the election risk mitigation guidelines that we published in April. We explicitly have a point where we encourage the providers to voluntarily open them up already. If it's not access now, then it will be access in November, because that will be the deadline for the reporting in Article 42. So that's the point at which they have to publish the risk assessment reports for the assessments that they did last year in August. And the last thing I want to say is we do, of course, already enforce Articles 34 and 35. There were a number of requests for information that we sent to the providers, some of them by decision. And They do concern risks, for example, of fostering addictive behaviors, of leading people into rabbit holes of addictive content, or insufficiently protecting minors, including in terms of their privacy. So here also there's a website. I know the Commission website is how it is, but there is an enforcement tracker where you can see for each of the providers what the Commission is doing, and there's sometimes the summaries of the opening decisions of formal proceedings. And I feel the time pressure now, so I stop now and then we can discuss. Yeah, okay.
Thank you. We have the time we have on such an important topic, but hope to have time for the audience as well. But still, Valentina, maybe quick reflections, also next steps from your perspective.
I will just focus on the two most important steps that we could make. And the first one would relate to the further consolidation of expertise on fundamental rights in the context of the risk management framework under the DSA, because there's plenty of space for further exploration by academics and also by civil society and practitioners. I'm, for example, also personally curious why Article 34(1)(b) provides also specific examples of fundamental rights, and whether it's intends also to set out some kind of implicit hierarchy between different fundamental rights. Because I would be curious why, for example, freedom of assembly is not mentioned, or even the right to intellectual property, which is also protected by the Charter. So we definitely need to do further work to understand how fundamental rights need to be interpreted and applied in this peculiar setting when we have private actors rather than states as duty bearers. And secondly, of course, we need to establish reliable channels for passing on this expertise to platforms. And what Eliška said regarding meaningful stakeholder engagements really resonated with me, because it is indeed unfortunate that the precise mechanisms have not really been spelled out under the DSA when it comes to Articles 34 and 35. We see it, of course, in some other provisions, for example, on codes of conduct. But yeah, when it comes to the assessment and mitigation of risks, we do not really see that spelled out very clearly. And that's, of course, an omission, we can say. But moreover, I think that there should also be more engagement between civil society and public authorities, because in Articles 34 and 35, we once again see a very prominent role for the Commission, the boards, and also national DSCs, which makes sense. But perhaps there is also room for establishing further collaboration between these authorities and civil society and even researchers. Because also when I studied the recent guidance on the mitigation of systemic risks for electoral processes by the Commission, what I also noticed is that there are some blind spots. Of course, it's a very important document, but I personally missed seeing more references to, for example, online gender disinformation, which is a huge threat for female politicians and for democratic discourse. And it's mentioned in passing, but I think that it deserves also more attention. And there has been significant academic work on these issues, and also some calls from civil society organizations on that. So perhaps there is also indeed more room for engagement with civil society and researchers from the side of platforms, but also from the side of the EU and member states authorities. Thank you.
Thank you very much for these two important points. Of course, gaps in knowledge exist, but also further engagement, civil society, but also academia, I think, is very useful on knowledge production. Daria, please, quick reactions to what you heard and next steps.
Thank you. I will be really quick. But first of all, let me say I'm not a computational scientist, but maybe communication and social science would be closer to what we do. First of all, I was really glad to know that soon the Article 40 will be really enforced. It would be good, of course, to know what's going to be there in the delegated act. And I mean, I hope it's not, before some researchers suggested that all the platforms should use API access system for selected, vetted researchers, but I think it's not enough, because API is another gatekeeping mechanism which can prevent from getting other types of research done. I hope I got my point through. And also, I think that the AI algorithms used in algorithmic moderation should be audited independently, also by researchers, perhaps. That with that, I agree with Valentina. And also the other documentation that is not available to neither researchers nor the civil society, like, for example, risk assessments. I mean, it would be great to see them somehow, but as far as I understand, Article 40 does not include that. Thank you.
Thank you for the good reactions. No, I mean, subscribe. We in our report also highlighted that a variety of methods is, of course, also needed, and data sources to tackle these challenges, as there is no silver bullet, one data source or solution. So this feedback is also very helpful. Quick reactions, and maybe next steps, Eliška.
I'll do that very quickly. So regarding the transparency databases and dashboards, I think that it's great that we finally make those legally mandated transparency operational, and we also expressed that in the consultancy response that we submitted to the Commission. It will be essential to connect the dots in order to truly understand and have that broader picture of what is truly happening on the platforms. These are the early days. The database, we still have to test it and see where those gaps lies, but having that more coherent picture will be absolute key, and I think we still have to get there. Regarding the risk assessment report, absolutely. But again, probably this won't be the whole entire risk assessment. It will be some redacted version or some main outcomes within the report. And we are not really sure at this point whether that report will contain those significant information that we also single out in order for us to assess whether this exercise was really done in a meaningful manner. To the hierarchy of rights, we noticed the same. I do think, just going back to negotiations of the DSA, these were sort of just singled out the rights that are mostly subjected by the negative effect of technology, and then the charter as a whole was added later on at the later stages. And then I think the word that will really matter there is systemic, right? So what makes something significantly negative and significantly systemic? And here I would also call on working with already existing human rights due diligence tools and research that exist out there, where due diligence obligations, either within the UN guiding principles on human rights, a number of other civil society organizations or experts developed further. Yeah, that I will just stop there. I could probably add other comments, but I know that we don't have much time, so thank you.
Thank you very much also for keeping the time. I was asked to keep 25 minutes for question and answers. We have 20 minutes. That's still quite good. I can't imagine that there are no questions. So I would like to open the floor. Kindly introduce yourself before you ask the question. I suggest collecting 3 and then letting the speakers divide. There was the first question. Yes, the blue shirt.
Hi, I'm Jeff Allen from the Integrity Institute. And a question for Eliška. I think it's awesome that you reached out to the platforms and tried to engage them in their process of writing the risk assessments. I was wondering if you could talk more about what are some of the successes you got from that, and then what were some of the challenges, and I can guess at some of the challenges, but being explicit there. And then maybe for Aika, a follow-up on that. What do you think under the DSA that engagement should look like between civil society and academia and the platforms in their process of writing the risk assessments and identifying the risks?
Thank you. Over there was another question.
Thank you, Oliver Marsh from Algorithm Watch. Boringly predictable question from anyone who knows me, but how, if at all, can the word systemic, picking up on Eliška's point, be turned from something that's a bit potentially confusing into something that is practical and useful, or do we perhaps just want to ignore that definitional problem and just focus on the list that exists in the DSA and assume that all of these things in that list are all, by definition, systemic risks?
Thank you. There was, I think first here we had the third question. and then we'll come to you after the first round of answers.
Hello, I'm Mathis. I'm a French student, and I have a quick question because I have a second question, and it depends on the first one. Is there an obligation for the platforms and I think the English word is search engine, to have a number of moderators in order to moderate illegal content? And if not, just for the context, there was a recent report of X that said that there is only in France 52 moderators for 11 million users, with 400 and 300 content of harassment, 16,000 deleted message in France. It is 7,000, sorry, in Germany. So, do the European legislators should have create an obligation for the platform and the search engine? I'm thinking about the illegal content like gore content or something like that. So an obligation to have a certain number of moderators in order to moderate in the correct way those contents.
Thank you. Very good question. So I'll give it back to the speakers. Eliška, you were directly asked, so maybe you start. You can not just answer this question, but also reflections on definition systemic risks, and maybe the last question. Then over to Eike, and then the others also have the chance to respond.
Thank you. The success regarding the engagement with companies. So I think we organized together at least 2 roundtables where we directly engaged with platforms specifically on the DSA and Article 34. And I believe, Jeff, that you attended at least one of them. And so those conversations were, from our viewpoint, quite difficult. Maybe at that time we were not exactly fully aware yet how to formulate our questions properly. And at the same time, platforms were very hesitant to share what is exactly happening due to a number of other concerns, how they actually conduct those risk assessments. We also received one clear answer at that point, which was, risk assessment is going to be treated as a confidential internal exercise, and we're not going to share that with public. Of course, under the DSA, they do have to submit a risk assessment. So based on that, we also then worked with the other work and research done by organizations such as BSR, for instance, where that stands sort of at the intersection of platforms and, the fundamental rights or human rights impact assessments, where we reviewed several methodologies that were available at that time. But of course, again, we worked with limited resources. So I would say it was a very moderate success, and we did not always properly receive that kind of feedback that we hoped for, and maybe the issues that we flagged to platforms, for instance, the harmonized interpretation of some terms within the DSA, if they understand that coherently, we actually found out that was not even an issue for platforms, that had a sort of a clear picture of what, for instance, systems and processes or technical functionalities mean in practice. I can also add to that very quickly, our partner organization, European Center for Not-for-Profit Law, conducted or tried to conduct a survey with platforms at the beginning of this year, and there was a radio silence. So this is where we are at the moment, and hoping that those mechanisms will evolve in the future. The definition of the systemic, so we thought about it as well, and again, in our review, also if you look into that significant negative effect on fundamental rights, which is also another term that DSA uses, we used again research that exists out there, and for instance, criteria such as severity, the probability, or also number of effective individuals or collectives or groups, especially if these groups are being historically oppressed. All of that should be factored in by those very large online platforms when they are coming up with identifying what is truly systemic. But that goes also back to the question, I would say, all those studies and research provided by experts and civil societies, we also often struggle with, is this systemic enough if we gather the evidence that there is probably a risk on the platform stemming from a concrete system, but will this be enough for a regulator to initiate investigation or request for information? So I think it's still very vague, and of course more clarity and specificities would be required. And I'm sorry, I did not hear well the last question. I think it was about the number of content moderators, but maybe, Eike, I think that this is better for you.
Over to you, Eike.
Yes, I can take that one. Maybe I start with it. There is not an obligation on an absolute number of content moderators. There is the obligation to be transparent. That's why you knew probably the numbers that you gave to us. And there is the obligation to have risk mitigation measures that are effective, reasonable, and proportionate, right? And it's also out in the public that in this month, we did send, I think you mentioned X, right? So we did send a request for information to X that also concerns the resources they deploy for content moderation. Yeah, that's, I think, the answer. That I would not go into the question of whether there should have been an absolute number of content moderators prescribed, because the law that we have is designed in another way. It requires the transparency on the resources and then effective mitigation of the risks. Yeah, I think then before I go to the other questions from Jeff and Oliver, I still had this point for Daria on the independent audits. This is also a requirement in the DSA. It's the Article 37. And it's not audits that would be launched or initiated by researchers that have an interest, but it's an obligation on the providers of the very large online platforms and search engines to contract somebody, an independent audit organization, to then do this audit. And the reports that they have to write up independently also must be published. It's in Article 42, the publishing obligation. Yes, then how the engagement between the providers and civil society and academia could look. It's again recital 90 that does give some examples, right? It mentions surveys, it mentions focus groups, roundtables, and then it's open and says other consultation and design methods. And I think it's good practice for the Commission not to point out very specific compliance solutions, but to say, okay, you have to work together, show us, and to leave the field open. I think that was it. Oh yeah, on the systemic risk, I just wanted to say that Article 3 of the DSA has a lot of definitions, right? It's very, very long, and this term is not defined. So that was the decision of the co-legislator as well. And there is something in Article 34, it's not only the word systemic risk, there is also the obligation that the risks shall be assessed specifically to each service. And I think it goes also for this assessment where the systemic risk is, right? It depends on the service, because there are a big difference between a social network and an online marketplace. And I think that's what I wanted to say to this question. Yeah.
Thank you. If you have any reactions, you can also to the question, definition of systemic risks, number of content moderators. I also like the question. We are often occupied with the algorithms use, which is important, but of course there are also humans behind. Please.
No, just very quickly, because indeed it's very challenging to assess the effectiveness of the resources employed in content moderation, and also judge the effectiveness of content moderation just by looking at the number of human moderators. Because we know, and the DSA Transparency Database has once again highlighted the fact that algorithms are now in charge, and algorithmic content moderation is the primary means of detecting and removing violative contents. So what we also need to do is look at how these human moderators are also embedded in this entire system of content moderation, and if they even have the possibility to meaningfully verify the accuracy of algorithmic outputs. And that, of course, goes beyond just this very quick check regarding the amount of resources and the number of human moderators deployed. On the definition of systemic risks, so indeed, I think I agree with other panelists that have already highlighted that, and the threshold has been omitted, also with a specific intention, so that we can also hear from platforms how they go about defining the systemic risks. And ultimately, the DSA encapsulates this idea of what Martin Husewitz, whom Daria has already mentioned, calls this risk management dialogue. But the problem that we see here is that this dialogue is still not happening. So hopefully it will happen in autumn 2024 when we finally have the reports. But we will see, of course, whether it will indeed be a meaningful one. Should I pass it on to Daria? Yes.
Thank you. Just 2 words, really, or 2 sentences. So the so-called father of our field platform governance, Tarleton Gillespie, who is, of course, now working in Microsoft, once said to us during a presentation for our lab that it's important to have points of access. So it is much better for the researchers in the US who do have points of access to these platforms, and it is a bit more difficult here in Europe. And I think these stakeholder events and roundtables and civil society attempts are all going in maybe this direction, and it's probably good to continue that. Thank you.
Thank you. So we do have time for another 1 or 2 questions. I know there was one in front, please.
Thank you. Is it on? Good. I'm from the US. I'm fascinated by everything that's happening in Europe, but I was wondering if you all could remark on anything that you've seen that is essentially the Brussels effect for DSA. So are other countries following suit, or are companies perhaps changing their behaviors in other markets to respond to the DSA and its requirements? Thank you.
Thank you. There's maybe time for one other quick question, if there's one more, or are we hungry? Fine. No, but that's still a good one. So let's take the last questions and also add any concluding observations in the last 6 minutes we have. Eliška.
Yeah, this is a great question. Thank you so much for that. We definitely start monitoring the Brussels effect of the DSA. We see a number of jurisdictions around the world that are getting really inspired. One such example could be Brazil. We also see similar developments in Costa Rica, for instance. And I would say that the way how DSA currently translates into these international legislative developments, and it was very nicely described by one of the academics at stakeholder event in Amsterdam that most of us actually attended who are here today. It can have either a symbolic effect, so we often hear regulators and legislators mentioning DSA when they are calling for more accountability of platforms, but then the laws that result from that pressure have very little to do with the DSA. And we see typical censorship laws that are aimed at suppressing dissent and critique against the government. And I would say Turkey is a very good example of that too. And then we see those other regulatory trends, especially around risk management measures such as Article 34, Article 35 that we discussed today, that is taking on, and where we see the potential that these will be translated further into other jurisdiction as approach to regulate platforms. So we monitor, and little self-promotion, Access Now is actually working on the report exactly looking into Brussels effect of the DSA.
Thank you. Eike, do you have a reflection also on the Brussels effect? Yeah.
Sometimes I can sounds like Eike, so I thought you were going to give that reflection. No, I would not. I would use my time differently. As a concluding remark, I would again do self-promotion, because we need your help. Again, for the panel on Friday on the delegated act on data access. Sorry, what do you say, Emilia? It's at 8:30 in the morning, so it was wrong earlier, 11:50. Please, it's worth getting up early for this. No, the thing is, one of the requirements to get access to that data, to study the risks, is that the applicant researcher should demonstrate that they are capable of protecting personal data. So there are also other requirements. But for this one, I think the people who come to CPDP are very well placed to help. So it would be, if you are in a research consortium with, I don't know, sociologists or whatever discipline there is, I think it could be great if you are aware of the possibilities that this article offers and get in touch with other researchers to start interesting projects to look into the risk research. And a good starting point to get into the details, into the concrete of it, will be on Friday at 8:30. So that was what I really wanted to say.
Thank you very much. No, we were fully aware with this panel that we open a lot of questions. It was framed in a very generic way, and we're in the middle of discussions. It's a very new, it's a dynamic field of regulating content online. It's developing at a very fast pace. So it's obvious that there are a lot of question marks, and that there are a lot of things to do for each of the different stakeholders. And this way I was so happy to see like really the different voices and representatives, as we should of course all work together to safeguard our fundamental rights. I mean, they are the agreed common standard that we should work with. We have a new tool, which is the Digital Services Act, and we can really embrace the provisions in there. I heard really positive examples on transparency, so I really like starting on the data analysis. Maybe there are still ways for improvement, of course, but we see the databases, the transparency database, the ad database, the terms and conditions database. There should be hopefully better access to the platforms. This is, of course, an acknowledged challenge at the moment, that the trend is rather closing down from the platforms than opening up. But this is really needed to get a better understanding, like where the risks are on online platforms. I usually like to compare this with the discussions we had with the tobacco companies years ago. Does it cause cancer or not? And there was a long discussion, can you prove this and that? And we're a bit in a similar new field where we are still learning, where we are gathering evidence to really show where the risks are and how can we address them. On that note, I take the very last minute, also self-promotion. No, one recommendation the Fundamental Rights Agency had in this area is, as I said, there's no silver bullet. We need different sources, different analysis to get a better understanding. What we do at the agency on a relatively frequent is surveys with hard-to-reach groups, with LGBTIQ groups, with ethnic minorities, and so forth. And in these surveys, we also step up the questions now on their experiences with online platforms. Accessing data on platforms is one issue, but asking people about their experiences is another one. So I'm just, for example, in summer we will publish a report on Jewish people experiences on anti-Semitism online. After summer will be a report from Muslims' experiences and so forth. So for all the different groups we try to cover also better the experiences online, and this will also feed into the discussions to better safeguard fundamental rights online. Thank you very much and enjoy lunch.